The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show, so here you go. With us today, Michelle Young in her downtown office, younginjurylaw.com, and as always, Dawn Moore and Dan Moore, MIA today, the Moore Law Firm on Nimitz View Drive, moorelaw.com. Of course, you can get all that information and see all the old shows that we've done, fox19.com. Just click on Moore Law. So we just have a few minutes left here, but I know you wanted to show the viewers, after Michelle was talking about open and obvious, you actually had a picture you wanted to explain a little more about that.
A great segue, actually two segues. Number one, Dan is open and obviously not here.
Correct.
He's still on vacation, which I don't know how that happened.
Wait, doesn't he have to apply with you for vacation time?
Yeah, he outdid me, I guess. The other thing, this open and obvious business is that Michelle's talked about a couple of times on the show so far this morning. That's a big deal. We've got a little picture here, and it shows a place where a person got badly hurt, and they've got tape across it and everything else. Well, even if the tape wasn't there, the condition of the stairway was awful, and you could tell from 15, 20 feet away. That is what the law refers to when they're talking about open and obvious. If an ordinary person, under the circumstances that existed at the time the incident occurred, should have seen it, then it's open and obvious. And that means that the person who owns that property owes them no duty, no matter how bad they're hurt. So you go off on a step that's in awful shape, it breaks, and you break your neck and you're paralyzed or you're killed, you know, name the bad injury, they don't owe you a duty because it was open and obvious. It was up to you to avoid the hazard. Now, there can be circumstances that would affect that. And basically, if you go down a step that looks just fine, and the landlord knew it was about to fall, and they didn't do anything about it anyway, then that's not open and obvious, and the landlord may be liable. But that open and obvious is a big deal, and it's how people who let bad conditions exist sometimes get off the hook.
Okay. Do you, both of you in your work, do you get many calls from people who think this bad thing happened to me, and of course somebody must be responsible for it, and really there's nothing you can do?
Happens every day, doesn't it?
It happens many times a day. Unfortunately, liability only kicks in if there is actually a duty to keep it, to provide care.
Right. Okay. Okay. Let's go back to the phones here. We have, I believe it's Mary in Springdale. Mary.
Yes.
Go ahead.
How are you?
I'm doing fine. How are you?
We're doing great, Mary. Thanks for calling. What you got?
If you're in a mall-like setting, an establishment that has multiple stores, and you slip and fall and injure yourself, like in the hallway, maybe in front of that certain establishment, is there the responsibility, the establishment, or do you have to go with the store owner?
Or either one, I suppose.
So if I understand, when you say the establishment, like if you're at a mall,
yes,
there's an area where everybody walks that's outside the store.
Yeah.
And you're asking what happens if you get hurt in that area where everybody walks, which they sometimes call a common area. Am I correct?
Okay, that's correct.
Okay, Michelle, what do you think?
I think that chances are you would have to go to the owners of the common area, not the store itself.
Yeah, I think Michelle's exactly right. That's what you would do. The people who are in control of the area are the ones who are responsible for it. And then the issue of, again, like we've been talking, it's a big deal. Did they do anything wrong that caused your fall? If they didn't, they're not responsible for your injuries. If they did, then they're on the dime and they're going to be responsible, or at least there's a good chance they will be.
So if it's raining outside, if it's snowing, and you walk into the common area and you slip, the store or the owners of the shopping mall are not responsible ordinarily, because you're expected to be able to see the open and obvious danger of walking into the mall after a rainfall or snowfall.
And that gets modified a little bit, at least in my experience. What you said, of course, is true, but it gets modified a little bit if they know that's going on and they can take reasonable steps to try and protect their patrons. That is, like absorbent rugs. So when you walk in and you hit that mat, it takes some of the moisture off your feet. So there's some things they can do. It's not all cut and dried one way or the other, but generally speaking, if it's there to be seen, you've got to see it.
I agree. Great point.
Great points from both of you.
Yeah.
Let's go back.
We're so smart, aren't we?
I know, it's a mutual revelation society today. Let's see. We have Mark in Forest Park. Go ahead, Mark.
Good morning.
Good morning.
My father took and fell in the hall off the sidewalk coming to the side door, and what I was trying to do was he sued the landlord city for that.
I wasn't able to hear
So
much of
Mark,
that at all.
Yeah, could you
Don?
try that one more time, Mark?
My mother fell in the hall on the sidewalk, eating to her side door, and broke her foot. And I was thinking she was on the far city fall.
You know, Mark, I'm just going to have to. I'm so sorry. I'm not sure what is with the phone, but I just wasn't able to hear you. You know, you can look up Dawn's number and Michelle's number at fox19.com on More Law, and I'm sure they will be happy to talk with you.
We'd like to help you, but we got to understand what you're saying. So call us back.
Okay, and let's go to. We have time for one more call. Sonia, please go ahead.
Hi, good morning, and how are you?
Good morning. We're
Hey,
good.
Sonia.
How can we help?
I fell a while ago while delivering some merchandise to a customer's house, which I did quite often. And my employer knew that I was having difficulty doing this because I did it at night and it was not lighted very well. So nothing was done about it. So I had to start taking an alternate route to his house instead of going the sidewalk from the driveway to his house because I couldn't see the steps. I would park on the street and walk down his little hill to his front door. And then one day I fell going down this hill and had a really bad injury. I did have an attorney, and they told me that because there was nothing in my path going down the hill to his door, that I had no case. Is that correct?
What do you think, Michelle?
I think we'd have to look a little more at the circumstances of what it looked like going there. You are responsible for taking special care in the dark, but I would not be able to, without seeing the driveway, see it was a genuine risk. You also are aware, if you know that there is a risk, to not take it. So I think it would count against you that you'd been to the house before and you knew that it was a risk to you.
Okay.
What do you think?
Well, actually, I think that there is one other aspect to this that we haven't talked about yet. Sonia, if you're doing that for work and it's part of your work, you got workers' comp. And you may not even have a claim against the boss, except for workers' comp. You need to file a claim right away, and it should be covered.
Okay.
I agree.
Don, Art, and Michelle, thanks for joining us. We are out of time for today. Coming up next week, though, we will have if you need legal help and you can't afford an attorney. So we will see you next Monday morning here on More Law at 9:30.